How does the attorney determine a Chapter 13 plan payment amount? The Chapter 13 plan payment can be difficult to determine. Now remember, it's a proposal. The client proposes a plan payment to the court that the court then approves or disapproves. And their approval depends in large part on what the Chapter 13 trustee has to say about it. So I always tell my clients, really we want to make both the Chapter 13 trustee and the court happy or satisfied with the plan payment we've proposed. Coming up with that payment is difficult, but it depends in part on the client's income and expenses, depends on the assets that that client is trying to keep and the value of those assets. It also depends on the nature and type of debt that that client has. And then of course, if the client has high income, there's something called the means test. And the means test is really this test that Congress put forth in the amendments to the Bankruptcy Code that helps determine also exactly what is the minimum amount that that client has to pay back in the Chapter 13. When an attorney evaluates all that information, he or she can come up with a proposed plan payment. Of course, we'll work with the client to figure out exactly what that should be and get it, frankly, as low as possible so that the client feels that they can still afford it, and then we would propose that to the court and hopefully have that approved by the court.